I'm delighted that my co-director, Professor Gilberto Leong, will be introducing the speaker. So it's over to you, Professor Leong.
Thank you so much, Kelvin. Welcome to the WYNG-HATTON lecture, which is supported by the WYNG Foundation and the HATTON Trust. The former is, of course, represented by Anna and Anthony here. We met them earlier today. And the HATTON Trust is represented by Ron, I believe, who is online presently. This year, the WYNG-HATTON lecture is on smart regulation for medical innovation, to be delivered by Professor Sir Jonathan Montgomery, who has been working in NHS for decades and is currently Professor of Healthcare Law at UCL. He previously served in many important positions, including the chair of the Health Research Authority and the Nuffield Council on Bioethics. And he's also honorary fellows of several professional bodies. So without further ado, really, I just want to give you Sir Jonathan. Thank you so much.
Thank you very much. And I'm very grateful for the honour of speaking, particularly as it's the 10th anniversary of the Centre of Medical Law and Ethics, even if I'm not sure you can count up to 10, Calvin, very accurately. And it's hard to believe that it is 10 years since Ron Zimmern bent my ear on would this be a good idea or not. And I'm very grateful to Ron for many things, but including from the HATTON Trust for the support of this. And it's a great pleasure to meet Anthony and Anna from the WYNG Foundation. I hope, Ron, Anthony, Anna, you know quite how special the centre is. So I'm really pleased to be here this evening. I'm going to explore the area of medical innovation and reflect on a way this is subtly different from clinical care and also from research as we've begun to understand it. So my aim this evening is to explore the challenges that we have in fitting medical innovation into the ethical paradigms that we have, particularly around research regulation. I'm going to do that, I hope fittingly, as a professor in the Faculty of Laws, we call it plural, in UCL, and also in this building of the Hong Kong Faculty of Law, through reflections on 5 cases that have come before the English courts, 1 or 2 of which I'm sure you will have noticed, and some which are probably obscure and possibly deservedly so. But I think out of reflecting on those cases, it's possible to see some of the challenges and insights we have on how we can regulate medical innovation. So I hope out of them to draw some ideas and pointers what good governance might look like in relation to medical innovation. So if I can start with a quote that I owe to Sir Ian Chalmers, who've used this in presentations, that we work quite hard in regulating things we classify as research, and we think quite hard about the doctor-patient relationship and the ethics that belong with that. But we don't think very hard about what happens in the attempt to innovate in the course of medical treatment. So this editorial from The Lancet suggests that if the clinician treating a patient is really strong in their belief that something's going to work, then ethicists don't get in their way, presumably because they think we're trying to do good. Whereas if you are more honest about the evidence base of what you're doing and you doubt about whether things work and you want to try and find out how to improve that, you find all sorts of regulatory hurdles that are put in your way. And that's the tension that I want to explore this evening. You can innovate, it can illustrate the challenges around medical innovation by thinking about 2 ways in which innovation goes wrong. The first is the mistakes that are made where patients are harmed, where people don't properly approach the experimentation in new therapies. So I work at University College London, and University College London has played a bit part, a marginal role, in the Paolo Macchiarini scandal, in which the surgeon Paolo Macchiarini now convicted of offences in this area, purported to show that he was dealing with a last resort therapy for patients who would otherwise die, purported to show that he was doing something very exciting in terms of stem cell regenerative medicine. The Karolinska inquiry in Sweden, exploring what went wrong, identified that part of that picture was that this process was not properly overseen as a research process because it was thought to be a clinical intervention that wasn't subject to the governance of research ethics. Now, the report took the view that that was an incorrect interpretation of the regulations, but it demonstrates how we find ourselves on a difficult line about the proper regulation of the risks and mishaps. UCL held its own internal inquiry into its part in allowing that to happen, as Paolo Macchiarini had an honorary position at University College London, and it gave a rather anodyne clean bill of health to the processes UCL has, both for considering innovations and also dealing with allegations of misconduct. But that illustrates some of the questions about where the responsibility might lie, which I shall return to later on. So we worry about apparent innovations going wrong, but we also worry about the failure to innovate. So Maurice Saatchi, member of the House of Lords, member of the Conservative Party, and also a key advertising agency executive, introduced a bill which got through the House of Lords and failed for lack of time in the House of Commons in our legislative system, driven by the belief that worries about legal liability stopped people adopting innovative treatments early. And this was a particular personal issue for him because of his wife's death from cancer. And the Medical Innovation Bill, as he introduced it, approached that problem of non-feasance, the failure to innovate, by trying to create a legal immunity, because his diagnosis of the reasons why people didn't want to innovate was that they were nervous about being sued if they did. There's not much evidence to support that. It raised a lot of controversy, and the version of the Medical Innovation Bill that finally made the statute book only picked up a transparency requirement about recording innovations. The idea of that being that if there was a register of innovations, then people who otherwise wouldn't know about things could find them out, choose to apply. And as far as I'm aware, although that's on the statute book, no one's actually implemented it. But the key thing for here is that if we're going to regulate well innovation, we need neither to fall into the trap of trying things too dangerously too quickly, nor to fall in the trap of providing disincentives for innovating. And this is also a problem in our research ethics paradigm. And I'm just using this shift in the Declaration of Helsinki, which for those who are not aware is the World Medical Association's codification of human subject research ethics, shifted between its 1996 and 2000 versions from a provision which understood therapeutic research, clinical research, where the clinician was trying to do the best for her patient, as being in a separate ethical universe to research ethics, where it was assumed that researchers didn't have an interest in their, they would have said at that stage, subjects' safety, and therefore we had to worry about the conflicts. By 2000, we shifted to thinking that it wasn't so much that clinical care in which we innovated was driven by clinical ethics, so much as it's even worse if you're doing research when you're also involved with the care of your patients. Probably, although I wasn't part of the negotiations on this, and others in the room may have been, because there's a concern about undue influence for clinicians who invite their patients to become part of research. Patients might be less likely to evaluate the risks for themselves. Now, I'll come back to some of that a little bit later. But the key point here is that that shift suggests that the idea of innovation within therapeutic relationships has become overshadowed by our paradigm for governing research, which is based on a utilitarian attempt to generate knowledge for the public good. And at least since the Nuremberg trials, we've been really worried that pursuing that sort of objective could well be at the risk of those involved in the research. So how might we think about these challenges of designing a regulatory process? Well, you've seen that my title is about regulation for medical innovation, not regulation of. And the reason for that is I think we need to approach our regulatory systems by recognizing that we are trying to achieve a range of social goods. I looked at some of the web presence for Hong Kong before I flew out, and rather like the UK, Hong Kong is pitching a hotbed of medical and other innovation as being part of the reason why people might want to come and invest and work here. And the UK has a life science strategy in similar sorts of terms. So part of our desire to be a good place to innovate is economic. Part of our desire is about creating an improved clinical base for the care that we give. So that clinical societal value and that economic societal value, they are all good things for our society. And we should then not be thinking that the purpose of regulation is to pull a guillotine down and stop them. We should, on the other hand, be confident that the way in which we regulate is actually moving us in the direction of realizing those social goods. And that's a complex challenge, but it's an important mindset to say we don't want to stand in the way of innovation. We do want to steer innovation in the directions that we want. And of course, in the context of the therapeutic interventions, which are as yet untested and unproven, there is also a desire that there will be good done for the individual who is going to receive those therapies. We can't, as a priori, know that that's the case, but that is part of our desire. That paradigm about medical innovation, I believe, is going to become more and more central because of changes in way in which medicine and science is going. So the more we get genuinely personalized medicine, particularly the more we deal with therapies that require products to be produced out of the material of our patients, particularly as we test our patients' genetic context in order to see which therapies work, we're going to be more and more moving away from the idea that the data on which our decision-making is based is traditional clinical trials. It's also true in the development of artificial intelligence and in devices, that key ways of developing devices are increasingly personalized and tailored to individuals. So it seems to me that we will not be able to hold on to the idea that we can separate research regulation and clinical care regulation for very long as we see this convergence and personalization of approaches. So I think there's a good reason to think this is not just about a narrow set of innovation cases, but about something we should get ahead of as science moves. We also need to be thinking about the strands of discussion about our ethical approaches and our research regulation, which I've got here under the headings of democratization and distrust. And they overlap, hence they're in the same bullet point, but they also have different elements. So we see a resurgence of cynicism about our regulatory systems designed to protect people and ensure good evidence for drugs to get on the market through right to try movements of various sorts, seeing the protective bureaucracies as holding back patient interests. We're also increasingly aware that the processes by which our current evidence base has been produced are distorted. So typically research ethics has been very nervous about the involvement of children in trials. I'm not sure research ethics, pharmaceutical lawyers have been very nervous about the inclusion of women of childbearing age because of the additional risks that creates. And of course, what that means is that the databases on which our medicine proceeds have distortions in. And actually that means in an area like pediatrics, that an awful lot of prescribing is essentially a form of medical innovation because it's done without the traditional evidence base. And of course, we know that the history of research ethics, I won't say it's littered, but it has within it some really concerning scandals about racial justice. So I want to relate the regulation of innovation to the desire to be able to offer evidence-based clinical practice to all the people we look after. So what we're looking for is people able to carefully and judiciously use an evidence base to translate a generic evidence base about populations and research cohorts into individual decision making. And that pre-assumes that the evidence base we have is connected to the clinical decisions that we need to make. And the closer you think about that in real life, the less plausible that claim is, and the stronger the element of judicious thinking, conscientious interpretation comes in that. So I think if we want to improve that, our innovation culture needs to be thought about over time, not as a snapshot. I'm going to ruin this in a moment by going to a series of snapshots, but then try and bring it back to saying, what could that tell us about trying to regulate in a way that ensures that we both draw on evidence and also contribute to the evidence base. So at the moment, I think we find medical innovation falling between gaps. As in the Macchiarini case, it's commonly articulated the idea that if something is not within a hypothesis-driven research process, it's not on a set of patients recruited as volunteers or genuine non-patient volunteers, it doesn't then need to go through a research ethics committee or institutional review board for oversight. It's also typically where we're using products outside our usual protective regulatory safeguards. So typically, we're going to be using a medicine for an indication or a group of people that it wasn't designed for and wasn't licensed for, and therefore we don't have a strong evidence base for. So that's an off-label usage. It's a regulated drug, but it's not regulated for use in this particular area. And an awful lot of pediatric drugs fall into that category. We also have provisions, and I'm using the language here from the European law, but there are similar sorts of provisions in other areas of creating specials, offering medicines purely on an individual patient basis. So not something that's on the market for somebody else, but just saying we're producing this for this individual case. And then we have mechanisms which in the European language are designed for group uses, categories of patients, but in other areas are used in a more intuitive sense of we have compassion for these patients and therefore going to use it. So we have a gap. We have a detailed regulatory system designed to ensure medicines only make markets with good evidence bases, but we also recognize that we need to innovate in the gaps that that creates. And I also think we need to think carefully about how those innovations progress into being widely offered. And we're not very good at the ethics of taking evidence, designing patient pathways and building services. And again, I owe this to Ian Chalmers. He will stand up when he's looking at the oddities of research ethics and keep reminding us that if you randomize and halve the number of people getting a drug, you need permission. But if you just use it in clinical care, you're probably going to get away with it under these things. And we saw that in one of the cases I'm going to talk about at a moment in terms of gaps analysis, where the judge accepted that the use of a monoclonal product, sorry, your phrase will come up a bit later on, I can remember the number, PRN 100. It's not a trial, because it's not an experiment. It's the provision of a treatment or procedure to an individual patient who is in need. Now, that's a slightly charitable view of the particular history of this product, as I'll say in a moment, but it illustrates the fact that we fall between gaps when we deal with this. So I want to explore this in the context of these 5 English court cases. Most of them are cases that come before the court because the court is asked to authorize a treatment which is either thought to be legally unavailable without court approval, or there's a dispute. So in the Sims case, this is a case where there's an incapacitated patient, or two patients, one of whom is named, Jonathan Sims, and there's a last resort therapy, but because this is an incapacitated patient, English law requires court approval when there's a proposal of an innovative treatment, which, particularly in relation to controversies. And that was also the situation in the University College London Hospitals and KG case that quotation came for. And although the precise legal basis for pulling things into court is a little suspect and under discussion, it's generally unwise to take this innovative step for someone you can't get a consent from without giving yourself some cover. So I'll talk a bit about the circumstances of that later on. The next two cases, and the other three cases, in fact, are probably ones that may have made the media, but not necessarily for the reasons I'm going to talk about. So the Asher King case was a child abduction case where the family fell out with the hospital in Southampton, where Asher was being looked after. Took him initially to Spain and then to Prague for treatment. And it hit the media discussions on the basis of whether or not it was appropriate to issue an international criminal warrant to bring the family home. And I'm happy to say I think that was an inappropriate response. But behind it is a dispute about innovation we'll come to. The Charlie Gard case, I can't believe anybody in the room hasn't heard something about the Charlie Gard case. At least the Pope and President Trump heard about the Charlie Gard case. This is a dispute case, but I want to talk a little bit about what we might learn from that in terms of court processes. And Bell and Tavistock is about puberty blockers. So this is immensely controversial in the UK at present. And out of it comes some reflection on what the courts are good and not so good at. So let me talk you through these cases and some of the things I think we should learn from them. So the Sims case was a patient with new variant Creutzfeldt-Jakob disease at the stage where there were no therapeutic possibilities available to them. This was not a dispute case. This was a case where the family and the clinicians thought that there was some value in trying a therapy for which there was some evidence base, but not a great evidence base. If you had other options, you probably wouldn't have explored this, but in the absence of other options, it seemed worth a try. And English law deals with these dispute resolution cases on the basis that it has the job as the court, the judge's responsibility is to identify what the interests of the patient require. So we tend to talk about that as a best interest case. So faced with a picture of this innovation, which was everybody agreed that there wasn't much other hope, this may not offer very much hope, but it offered some hope that there was a scientific rationale for doing it, then the court approved that treatment going forward. But importantly for our legal context, the judge also expressed an opinion on whether or not, had the treatment gone ahead without court approval, that would have exposed the clinicians to the risk of legal liability for malpractice, which in English law and indeed in Hong Kong law, I think, is governed by a peer review standard known as the Bolam test from the case in which it was first articulated. Although if you're in Scotland, you give it a different case name, it's essentially the same test. And fundamentally, that says our accountability standard is against what would be judged as responsible practice by an appropriate comparator group. And Elizabeth Butler-Sloss, president of the family division, the most senior family judge at that stage, offered the view that the Bolam test did not hold doctors back from innovating because, she argued, that if you are taking a step that has an evidence base in the interest of your patient, you're doing what responsible colleagues would think you were doing. And you don't have to do the same as they would think they would do. They just need to recognize that what you're doing is responsible professional practice. Chassis expressed the view that you do not need to worry in the innovation context about legal liability, provided what you're doing is in what you perceive to be the patient's interests, and your colleagues would recognize the basis of that decision. That's exactly the opposite view to the view taken by Lord Saatchi in drafting his bill, that doctors were an empirical question and should, a legal interpretation question, be anxious about being sued. It's fairly clear from this case that the judicial expectation is that they're not at risk of being sued, which doesn't, of course, answer the empirical question about whether doctors fear being sued, because you might fear being sued even if you're unlikely to be sued, and even if you were sued, you would be likely to win. So we need to keep those things separate. You can still have a disincentive to innovation without the law actually saying that. So what about the Asher King case? So this was a case where actually there wasn't a dispute in the sense that we'll see in the Charlie Gard case, because the hospital recognized that the family's preference for proton beam therapy for a condition I can't pronounce, at least not in front of a lot of people, medulloblastoma. Is that close to dealing with it? They didn't disagree that this was a reasonable thing for the family to think about, but it was not a standard procedure in the National Health Service. It was subject to a process of national review, to a reference panel, to whom the hospital had already made one application and was making another at the time when the child was removed. And at that stage, the NHS view was that this therapy was not proven in relation to the particular condition the child had, and that there wasn't a sufficiently strong enough reason to think that that therapy would be of net benefit to existing more conventional therapies. So the issue that came before the court was not about whether this was the appropriate innovation, so much as about the process by which you would seek approval. Before it was known whether this treatment would be funded, the family removed the child from hospital, and quite understandably, because the child had quite significant health needs, the hospital needed to raise the alert and they needed to find out whether the child was safe. The mechanism the family had used included going abroad, and the whole thing escalated into a major conflict situation. But the conflict was not about the innovation. It was about the process and the length of time it was reasonable to wait to get there. So by the time the court came to resolve it, the court process itself had seen the clinicians in Southampton speaking with the clinicians in Prague and reaching a consensus on what the treatment plan would be. And then the context of dispute was really about whether the NHS could pay for it. The NHS now pays for this because since the case, not because of the case, but since the case, they've reviewed the evidence and reached the conclusion that it was appropriate for this treatment now to be funded. So what lessons might we learn from the Asher King case about our approach to the regulation of innovation? Well, I think the first one is, if we're trying to understand what's going on in a regulatory process, the place to find out what's going on is not going to be the media accounts. Not necessarily in this case because the media accounts were completely inaccurate, so much as because the thing that was of interest to the media is not the thing that's of interest to me in this context. There's also something about understanding the regulation of innovation in a time frame. So waiting for an evidence base is a virtuous thing for the National Health Service to do when it's looking at the stewardship of public monies in order to spend it on therapies that work. So in that sense, it might be a virtue to be patient from the NHS provision. On the other hand, from the point of view of the parents of Asher King, very understandable why they didn't think it was necessary or appropriate for them to wait for the NHS to catch up with what they believed was an appropriate intervention. And if the issue is not stewardship of public money, but the issue is about whether or not this is a potential innovation that's a risk worth taking, then why should we lock them into that NHS process? And one of the features of the UK's National Health Service is that we're not very good at disentangling prioritisation decisions that we make on the basis of resources from prioritisation decisions that we make on the basis of evidence. And our National Institute for Clinical and Health Excellence, NICE, has a process which brings those things together in terms of whether or not the benefit the evidence suggests we get matches the commitment that is required, loosely calculated on the basis of would the money be better placed elsewhere. So a new spend needs to be approximate equivalent or better to an existing spend in terms of disability adjusted life years and that sort of measure. So we're integrating very different perspectives on what's at stake. But I still think it's reasonable for us to think about a degree of patience as a virtue around medical innovation. I still think it's reasonable for us to criticize the family in Asher King for not waiting to see whether the review process led to a resolution or at least an illumination of the risk-benefit issues. So I think it's reasonable to say to a family like that of Asher King's that discovering whether or not the review of the evidence done by the NHS gives you information on which you can make the judgment about whether you think this is an appropriate innovative treatment for your child. That's part of thinking, how can we improve the quality of decision making? We could reasonably criticize parents who just went for an innovation without any reason for thinking it was done, at least if it produces some risks for their children, either by not having other treatments or in the treatment itself. So my lesson from the Asher King case here is that we should be thinking in our regulatory framework about there being some form of due process expectations, and that should sit not just in our clinicians, but also on the side of parents as proxies. And I suspect also in relation to patients, although I'm not in a position from these cases to elaborate that so much. So I said we might reasonably expect parents, at least, to think about the evidence on which their proposed innovations are based. And that was a key part of the next case I'm going to talk about, the Charlie Gard case. So Charlie suffered from a very dramatic mitochondrial depletion syndrome. You might be misled by the media in thinking that the Great Ormond Street team fell out with the parents from day one, but actually they had looked after Charlie for many months. The parents have been accommodated in hospital accommodation to enable them to be there with Charlie. So the story doesn't start with the breakdown of trust, but it clearly gets there. The parents wanted a treatment that had never been used on humans, had barely been used in animal models with a condition similar enough to Charlie's for you to generate much by way of inference from. And to cut a very long and complex story short, Great Ormond Street, as it needed to do, brought the case dispute in front of the court. And it went through many layers of courts because the parents and their advisors were not content with the court decisions and kept challenging them. But part of the analysis here for me of what I call the tragedy, in a sense of Greek or Shakespearean tragedy, that's to say we have well-meaning character desires here to do the right thing, but they sometimes force us in a tragic direction. The hospital recognized a degree of humility, or maybe they recognized a degree of legal inevitability that they had to go there, but they needed to subject their reasoning to some form of oversight. They didn't use either their own clinical ethics committee, which at Great Ormond Street is a pretty well-developed system. They didn't use that because Charlie had a catastrophic incident that they thought removed all hope. But looking back, I imagine they think, wouldn't it have been better to have taken it at that stage and run that thinking past their clinical ethics committee? And the court identified that the use of clinical ethics committee was a good thing to do from this, because it's a proxy for this humility of recognizing you might be wrong and testing it out through views. And there are lots of different ways of using clinical ethics committees. But the basic idea here is that if we're dealing with an innovation and you don't know very much about it, more heads around that problem is likely to improve your decision making. The court also suggested that we might think about the use of mediation to avoid things coming to court. I think that's not a terribly useful avenue to go down in a case like the Charlie Gard case, because it comes too late. By the time you've got this controversy, it's probably no better amenable to mediation than it is to court resolution, which leaves everybody unhappy. But again, Great Ormond Street has a pretty good system for mediation and supporting of decision making, and didn't use it in this case. The next thing about the case, which I think is crucial, is the testing of the parents' experts' view on what was appropriate. And again, this is quite a long story, but the American professor who the parents believed could offer therapy for Charlie, the court found had essentially misrepresented the evidence base. So in court, he explained a very low probability of success. And the following day, he wrote to the parents saying that there was a good chance that Charlie would benefit from this. Now, whichever one of those representations is right, it doesn't look very good to shift in that way. It didn't look very good when asked about the situation. He admitted in court that he hadn't seen Charlie's notes. So to build a case for innovation without actually thinking about the specific circumstances is suspect. And it didn't help the court's view very much when Great Ormond Street managed to squeeze in through a slightly odd route a hint that he stood to gain if this therapy became a commercially viable product, and therefore was put in a conflict of interests. Now, the key thing from this, I think, is that this shows a process of testing out what do we need to think through when we're looking at an innovation, and the possibility that an independent review process tests out the coherence and robustness of the explanation. You don't know which way that's going to go in the end, but it is a process for giving us more assurance that there are reasons for moving ahead on this innovation. So what do we learn from the Charlie Gard litigation? I could have a very long slide on this. I've limited myself to just the one. The first of which I've touched on, which is, as I thought about this, I thought, what problem are we trying to solve here? The problem we're trying to solve is that people have really good reasons for wanting to do what they do, but they can get out of hand in the way that they do in tragedies. So we need to try and distinguish genuine optimism from hubris, where that's been taken to such an extent that it no longer has a basis in the rationality. We need to distinguish the obvious desire for parents to look after their children and to do the best for them from the obsession that comes where they're unable to assess the evidence and deal with it. Now, whether you can do that except in a dispute case, I'll leave perhaps for discussion, but the need to regulate with those character flaws in mind seems to be quite important. I'm also very happy to stand up and say lawyers can cause more trouble than good in this. Now, particularly the way in which lawyers in a couple of these cases have just taken everything through multiple layers of appeal when it was pretty obvious to everybody that they weren't going to succeed. That cannot have helped the family deal with this clearly very difficult environment. And I'm not going to argue, therefore, for us involving courts all the time in this. What we do learn from this, though, is that it seems really important for us to find a way of us exploring the different viewpoints and understanding whether or not there is a basis from the desires that people have for particular innovative steps. Remember that in the Asher King case, this sort of process actually found the common ground between the parties on a clinical basis. So we might look in the innovation for saying, how can we create a situation where the different views are subjected to a check on what's there? And that might be a clinical ethics committee. It might be a form of mediation. And I also think we need to try and disentangle what we think is at stake in these difficult decisions. And I've written this up, so this is just a align on this. But it seems to me that if the issue is about the probability of treatment working, or whether it will work for the particular condition that have, then that does belong in the scientific context and does need testing against the epistemological rules that we've developed for what counts as good scientific knowledge. That's very different from whether small risk success is worth taking, which we would usually say is highly person specific. And we would leave for someone who could decide for themselves up to a patient. And we have to think about how we do that for proxies. And also, I think we need to think that there are constraints that we put into the regulation that we legitimately expect people to do. So I'm firmly of the view that we should resist the court of public opinion model. And therefore, I didn't find either President of the United States or the Pontiff's intervention in the Charlie Gard case terribly persuasive on theological, political, or any other grounds. So that takes me on then to the UCLH case. So this is another Creutzfeldt-Jakob disease case, but not new variant, a sporadic. Well, I can't quite tell you what the difference is on that, but the key point from this is it's a rare condition, only about 100 patients per year in the United Kingdom, and I think about 1,000 globally. It's something where if we're going to do anything, we have to do it very fast because the expected time from diagnosis to death was only 6 weeks. The particular patient in this, who was older and healthier and fitter than most, was expected to do better than that 6 weeks. So it wasn't quite a 6-week window. But we have to have a system which enables us to work quickly if we're going to innovate in this area. And if we're dealing with a cohort, a rare disease cohort with a small number of people, our traditional models of setting up trials on this are not likely to be able to deliver anything. We have a situation where there's apparently no cure known from this, but for some years, team at UCL and UCLH have been working on this monoclonal antibody, PRN 1000. I missed a naught off when I remembered it. I apologize for that. Now, you would expect this to be funded through a clinical trial, but they were unable to get funding. So what they did was they developed a plan that if a patient came in, we could at least have this product which we've been developing and use that. And so they geared themselves up to be ready should a suitable patient arrive. This was also, there was also a particular time pressure on this, not just because of the 6-week diagnosis, but also that this monoclonal antibody had a shelf life. And if they were going to use it at all, they had to be able to use it quite quickly. So they really couldn't wait to go around another clinical trial funding regime, or they would waste the particular example of the product that was there. They took it to court, and in the court account, this is another one where there isn't a dispute. The court was satisfied that there were sufficient indications for the animal studies to justify the treatment going ahead. Now, I think there's a few interesting lessons from this about regulation and approaching innovation in an anticipatory way. So because UCLH knew they had this problem, they got talking early before they had a patient in mind. They had a product in mind that they could use. It hadn't been through the regulatory processes, but they went to the Medicines Healthcare Product Regulatory Agency, and they got confirmation. This fell into what I described as a regulatory gap earlier. They also went to the official solicitor, who in the English system represents people who can't represent themselves, early to discuss how they would do it, and they provided training to their staff on how to deal with it. I think I'll take a bit of personal credit for that, because in one of the early committee discussions, I said, you're going to need to go to, so you might as well start now. And they set up an oversight committee that, according to the court, had a clear and thorough plan for protective monitoring and oversight. I have a slightly different view about how committees work in UCL and UCLH. But a key part of this was the court reasoning used these processes and the reputation of the unit and the fact that this was driven not by commercial profit-making interests, but by respected academic and research funders as part of its rationale for saying this innovation step is one that they could improve, they could approve. And then we come to the Tavistock litigation. Well, I don't want to get bogged down in cancel culture and all the arguments around transgender rights. What I do want to say is that when this dispute, which came up as a judicial review action to the way in which the Tavistock clinic issued dispute said puberty blocking drugs, but actually it turned out the Tavistock clinic doesn't prescribe puberty blocking drugs at all. It recommends to other places which are looking after the young people that puberty blocking drugs should be used. The divisional court got sucked into the politics of this and came out with a view on whether young people could consent to the use of puberty blockers, which, as the Court of Appeal pointed out, was unsupported by any evidence that it had heard. So for a different talk that I'm giving in Cambridge next year, I'll say a bit more about the importance of legal rigor in that. What I think is really important in terms of us thinking about how the court approached this is, first of all, its approach to how you should regulate innovation when the innovative impetus is concentrated in one place. So separate from the case or connected, although connected with the controversy, the NHS has done a review of this and has identified the problems of having a single centre. It didn't surface this particularly explicitly, but it's there if you read the report, that one of the things that's happened at the Tavistock is that it's diverged from, or it's failed to keep up with the development internationally about the appropriate use of puberty blockers for transgender patients. And there's also a sense in which they identify that if you have a single centre, the risk of groupthink is magnified. And I think you can also say that about the Guard case. The Guard case had lots of other opinions from UK clinicians, but I hear, and maybe people in the audience can tell me about that, but the UK view on the risks and opportunities from this is possibly a UK view and wouldn't necessarily have been shared if there'd been a broader set of common opinions. So there's something about, if we use reputation as a signal, as we did in the UCLH case I just spoke about, we also need to be confident that we're doing that appropriately. But also really clearly in the Tavistock litigation, they exposed the fact that this centre had set up a clinical trial which was not being followed through at the pace required to generate the information on which decision-making was made, and that the service was unable to produce to the court proper information on the cohort of patients that it looked after. So even though in the Tavistock litigation, in the end, the Court of Appeal stopped the court being using to challenge this innovation process, it did expose two key worries about innovation that we need to worry about: the sort of groupthink problem and the importance of learning as we go through. So what have we learned from these cases? Well, I think first of all, those cases show us that the belief that the worry about regulation of innovation is because you might get sued is a myth. And I don't mean by that it doesn't exist. I mean that it's a story we tell, which does change the way we behave in some ways, but when we puncture it, it turns out not to mean what we think. Because liability rules are broadly supportive. Even the fact that we have these regulatory gaps usually ends up with innovators being able to do what they want to do. And usually, when you put a case to a judge, she's likely to say, go ahead and do it. So the SART-G bill was not the right sort of focus. But we have identified, I think, that we need to think about regulating innovation both for immediate issues and also to think about how we get a cycle of innovation into the future. So I think it's important, the Guard case shows, to test the claims of innovators in some way, because they don't always stack up. It's important to recognize that the fact that Asher King's parents were probably right, and it was a risk worth taking. Not necessarily right that the evidence was strong enough for the NHS to respond at that stage, but we were clearly at a stage in the cycle where it was a reasonable thing to think about, as indeed the hospital clinicians recognized. We also need to recognize that you can innovate badly and not learn from it. And I think it's implicit in that the innovation we want to regulate for doesn't deserve our respect as an innovation, something new and progressive is implied, unless it is in a cycle of evidence. So it learns to a degree from what we know already, and it offers something forward. We've also learned that a responsible innovator can demonstrate that responsibility by putting appropriate processes in place. So thinking ahead and getting your ducks in a row, knowing that you're going to need it, instead of waiting till the last minute and then suddenly trying to do it, which is unfair to the patients and their families. It's also unfair to the court process and supporters. If you can anticipate, you should. And we can do that in a number of ways, including use of clinical ethics committees or other forms of support. I think we've learned that responsible innovation requires that you don't assume you know it yourself, and you submit your decision-making process to some form of review. As I've said earlier, we make that mandatory for incapacitated patients. We don't elsewhere. I'm not convinced that prior review is always needed, but it probably needs to be available at least as a dispute resolution process, because sometimes that dispute resolution process enables us to find the common ground, and using it earlier, that would be the mediation model, might do that more effectively in areas of conflict, but these are not all areas of conflict. We do need, I think, to rethink our approach to conflicts of interest concerns. So the shift I showed you earlier from 1996 to 2000, now you can see as a different view of a problem which is held commonly, which is that a problem in research ethics is that it puts people in conflicting roles. And Alex London published a very interesting book last year, so I'm only halfway through, so I haven't been able to draw on, called Common Good, which is arguing that actually we need to rethink that process. We need to think about the alliance of interests between researchers and participants, and in our context, patients, in order to understand really what good regulation would look like. But fundamentally, I think if we rethink, and I support Alex's position, we need to think about how we integrate care and knowledge generation better, thought more broadly than just experimentation. The current Declaration of Helsinki still has this separation. It's currently under review. It's still a regulatory gap approach. So how should we move forward? Well, I think if we think about innovation as being in a cycle, it's quite proper for us to say allowing people to step beyond currently established practice enables us also to say you have an obligation then to make sure you feed back in what you've done. And I think that fits best as an institutional responsibility, that there must be a degree of infrastructure which enables us to ensure that we feed back our learning. And I'm very grateful to a friend and colleague from UCL, Sir Ali Zumla, who messaged me about an hour ago to point me to the new SCIOMS guidance, which in it talks about institutional structures to manage information as learning organizations. And that's very much the thought that's in my mind. Secondly, we need to think that the patients in these innovation circumstances are also bound into this model of they are part of an innovation process. So when we were reviewing at the Nuffield Council the move towards permitting mitochondrial replacement therapies, part of our logic was they should only happen in institutions that would at least set out to gather data. And part of our worry was that we really wanted to say on the parents who are using it, if you're permitted to do this, you should also have an obligation to commit to some follow-up, because you're part of a project here that other people could have been part of. You have taken away their opportunity to do it. And if you take away that opportunity, you should be making at least some contribution to that knowledge production process. You couldn't, of course, bind in the children, but you could reasonably bind in the parents. And secondly, we need to promote this virtue of humility. I've talked about subjecting views to peer review, to external scrutiny. It's also really important that we learn from things that don't work. as well as things that do work. So we have a similar issue in this innovation cycle as we worry about in research integrity, which is if we only report our successes, we're not really learning appropriately. So it seems to me that if we want to take that forward, we need not to integrate the regulation of innovation with research ethics. We need to integrate the regulation of innovation with the way we regulate clinical care. So taking a UK, so indeed an English perspective because of the way things are operated, we already have quite a lot of provisions in our registration system for those licensed to be health providers, which relate to ethical concerns, consent giving, and the like. We include in that things about good leadership, and we could quite easily integrate that learning organization characteristics. So in order to be registered, you have to have a minimal standard of showing you're learning from the processes you do. And in order to get well graded by them, we could define what this looks like in a more detailed way. And we require our NHS organizations each year to publish a quality account, which puts in all the various national audits. And you could include in that obligations in terms of research and also in terms of innovation. We also need to think about similar type of problem with innovators as we worry about with researchers who in the past have not published their results or registered their protocols. But we need to think about our researchers approaching this with integrity. So we already have a nascent model of research passports that enable people who've demonstrated they've had the appropriate training on good clinical practice and the like to be identified as suitable to move between organizations. We also need to think, how do we create a track record of people who are working at the cutting edge that would help the institutions that employ them know how to oversee what they're doing, just as importantly, help people who are offered the chance to do something untested and untried to think, should I place my trust in this particular clinician? And I think our consent processes, rather than being bound up with, have you accepted the risks of this treatment, need to think about, are you part of an innovation cycle? So the consents we want include the contribution of learning, so the information going in to some form of feedback. And strangely, this is remarkably similar to the position I got to with colleagues at UCL when we were worried about how we might set up a regulatory structure for stem cell and regenerative medicine. I started with Pablo Macchiarini. I'm sort of ending up back there. We thought that what we needed to do was to create a sort of social contract model for what we were aiming to do. It had some components, guarantees of scientific competence, openness to recognizing that the clinicians and the immediate patients are not the only stakeholders in this, the recognition that we needed to learn from this in a transparent way, which could then lead to accountability. And my general approach to governance, I think, is that as we do that, as a regulatory system designer, what we need to do is try and make sure that all those involved in this process get what they are looking for out of it, whether that's an immediate attempt at an innovative process, whether it's a system needing to learn from that. We need to get that out of it, what people want of it, with as low transaction costs as we can, so as efficiently as possible. So for me, that means the model here, it's not about gatekeeping as a research ethics committee. It is about oversight and smart regulation for innovation, medical innovation, belongs in the same area as clinical innovation. And Calvin asked me how I translated smart. So I guess I should end by saying, maybe smart is terribly technical, but maybe it's smart in the sense of we have a smartphone in which everything is collected together and deals with it. And maybe if we can collect it into one integrated governance system, will also turn out to be smart in the sense of wise. Thank you very much.
Thank you so much for your words of wisdom, Professor Sir Jonathan Montgomery. There are some very important questions that I think we can take on in this discussion. I thought about a number of points that our colleagues have also raised. For instance, Imogen Gould and Jonathan Herring from the University of Oxford when thinking about the role of courts in these sorts of disputes. So and also I suppose the cultural distinctions that you see in this part of the world, because you do not see courts as taking this sort of role as we see in the UK, for instance. And then, of course, there would be questions about regulatory gaps, as you've mentioned, and how do we address these sort of uncertainty and to involve patients in particular as co-producers. So with this, got the privilege of having with us colleagues, scholars who have thought long and hard about these issues in the context of mainland China. And these would be Professor Zhu Wei as well as Dr. Qi Ping. So may I invite both of our colleagues to the front. They'd like to come forward. They will share their thoughts and reflections of what Professor Jonathan Montgomery has mentioned to us, and to bring in the mainland context. So we'll first hear from Professor Zhu Wei from Fudan University, and then subsequently from Dr. Qi Ping, who's much closer to us, just across the border from Shenzhen. So Professor Zhu Wei, it's over to you.
Okay.
Professor Zhu Wei will share her comments in Mandarin, so please do use the headsets if you should require the assistance with translation. Thank you.
Okay, thank you. Thank you, Professor. And 我今天就I just speak Chinese Mandarin, it's easier for me. Thank you. 我今天听了这个Professor Johnson 的这样个这个发言这个我讲一讲从我这个角度如果我有不全的地方讲错的地方，我们在我们这个中国的同事来进行补充那么他今天讲到了这英国医疗创新面临的问题，从5个案例来提出了如何对待监管这个医疗创新的一个建议。那么他界定了医疗创新面临的一个挑战，我想他是讲了2个，一方面就是说临床治疗和研究是很大的不一样，那而医疗创新就是这个介于2者之间，这是所以这是一方面面临的一个挑战。第2个挑战就面临着经济和社会价值问题的一个挑战。那么这些挑战这个也许从社会和个人价值这个状况的挑战，我觉得是更为严峻的，比如社会不信任的问题比如这个医疗界利用这个 right to try 不断的进行突破那么在不信任方面，比如说我们也面临的问题，比如说这个排斥儿童和妇女，以及在研究中的这个不公正的现象，从而导致了整个社会对科学研究的一个不信任。那么他所讲到的这个我们这个对医疗创新存在的一些问题提出了未来的发展如何来进行一个规范。那么他提出了医疗创新要有循证的证据，那么这个是非常好的不仅仅是医生的个人的判断，那么这种创新应该制度化、流程化、标准化，应该有监督，应该关注利益冲突的问题。那么这些都是我们也存在的问题。所以他提到的问题，其实我们在中国在医疗创新方面也有存在着同样的问题。其实我们在2008年就在上海发生过一个人工这个心脏的医疗创新的问题，结果发生了很大的医疗纠纷。当时媒体有很激烈的一个讨论。那么病人家属说你是用我的孩子做研究医生说我这个是一个这个医疗创新。那么家属说我没有理解，你知情同意没有告诉我，你匆匆忙忙签的我是治疗，你为什么把我孩子当作猴子一样去展览？因为他说这是一个亚洲的一个创新，所以这个有很大的一个纠纷。那么这种在很大程度上当然知情同意的不充分，但更多的我们可以看到的是整个社会公众对这个科学界和创新医疗这个事情的不理解和不信任。那么这里这个比如说那个循证的证据缺乏，这是他的创新医疗存在的问题。还有呢，他往往病人是非常脆弱，因为比如说在这个2008年这个案例当中，他急急忙忙的要签字要救孩子，所以在这种情况下他就缺乏有效的选择能力。那么与此同时 医生他往往很偏重于创新，他会用这种在这个2008年这个案例当中，他就用这样一个，他觉得他创新，他可以这个发论文，他可以拿课题跟国际合作创造亚洲最小一例的人工心脏的这个。他这种医生的这种对新治疗理念的偏重和偏移，就可能会导致后面对风险的评估和结果这个发生这个问题。所以这个是一个问题，就是我们共同的问题。当然我们在中国也有这么个案例。第二个问题就是我们共同的问题，就是一个监管的空白的问题。正因为一个医疗创新是基于研究和治疗之间的，所以我们要么用研究的方法加以监管。我们很多现在创新医疗，包括 off-label 的药物，我们是用研究的方法来进行的，我们来进行伦理审查的。那么同情用药，我们是会在这个 proposal 里边要求你后续你是不是有个同情用药，那么也是用一个研究的方法来进行监管。那么在这种情况下，可能会导致的就是很多是太过严苛的方法，但与此同时它不走，因为研究伦理是这样的，你报我就审查，你不报我就不审查。那么所以有的可能我们漏了很多，它是走医疗的一块，它不要通过研究伦理来审查。那么这个是我们这个空白，可能在英国和中国的表现有点不太一样，但是这个空白是存在的。那么这种后面就是可能就采取我们这个中国可能采取宁紧勿松，就是说我宁愿紧一点而不要松。那么这个就可能会后面会有这样一个问题，那么这样就是可能使得大量的医疗创新的问题没有揭示出来存在的问题。那么这是第二个。第三个就是我觉得他今天讲的这个视角非常非常好，就是当我们出现的问题的时候，我想到的是问题是我们监管不到位的问题吗？中国改革开放40年我们出台了 numerous 的法律法规和监管的措施，但是到位了没有？我们大家可以看到不断有丑闻出现，不断有医疗腐败的出现。那么为什么会出现这个问题？那么其实它是从英国的这个角度来提出了问题，其实也值得我们去思考的一个问题，就是说比如说我们公众对科学的认知，对创新疗法的认知那么和科学界的认知是存在着极大的差异的，而这个之中的沟通是不足的。那么第四个，我非常非常赞同他的建议，就是说在鼓励创新的时候，我们包括研究者，包括其实整个社会都要承担起增进科学知识的义务，而且要增加这个透明度。那么也正是从他的这个发言当中，我也发现我们在中国，我们基于中国的这个社会状况，我们对于其实医疗创新它所掩盖的些很多的问题的揭示其实是不多的，社会公众的讨论也是不充分的。比如说在英国有这个线粒体替代疗法的一个替换疗法的一个公众的讨论，然后形成了一个最终的一个决议在中国是没有的，这是一个很大的差别。第二个差别也就是我们讲到，就是说我们对案例的剖析不够，公众的认识度不够，所以他都会关注于比如说医疗腐败或者丑闻那么这个大家的关注的比较多也从而从深层次的角度来吸取教训，这个角度和认识这个角度还是不够的。那么我这个由于这个公众和患者对这些的不了解，由于我们对医疗创新的监管其实还没有开始行动起来，起码我从这个发言当中听到了他们英国已经开始在行动起来，但我们这个开始可能还没有开始，比他更在前面，所以这个是我们这个可能是不一样的地方。那么也还有就是刚才我讲的，那么这种没有行动起来的这个状态呢，有可能是要么用过严的这个方法来监管，要么有过松的方法，走两个极端。那么这是可能我们面临的一个问题。那么还有一个呢，就是说我们很有意思的，我看到他说 right to try， 我们在我们中国社会不会用这个词，我们会说为了社会的福利，为了科学的进步，为了科技的创新为了人民的福利，我们会是这么来说话。我为什么去这么做 用这样一种这个视角这个视角也有不同。那么还有一个就是说，我们就是这个现在我们中国或者我们可能有行政力量比较强的这个情况下，可能他会做的就是在制度层面上要加强监管。那么尽管如此，可能还是会存在差异的。那么我们现在其实还是要做的，就在公众中的讨论还有教育。我们现在有各种病人这个 group 但是它还没有上升到让病人主动的参与，我们还不够，但是已经有一点点开始了，这是一个好的兆头。那么这个是我们要这个是不一样的。那么还有一个就是我们要做的就是，其实我们就是在中国一些医院当中的临床委员会的作用，临床的委员会、医疗的委员会的作用的是发挥不够的。那么其实在医疗创新方面，就是从我们目前的情况来看，其实这个临床的委员会和研究的伦理审查的委员会更应该他们的工作和监管工作应该更结合起来。那么这样呢，可能对我们这个医疗创新这个目前开始行动起来的一些这是一些想法吧。好，谢谢大家。谢谢。
非常感谢诸位教授。吉平博士，请发言。
按一下。
好，大家好，我觉得也是，其实刚才记着朱老师说，也是收获特别大。就是我从一个学习者的角度，因为我也不是学法学的，也不是学伦理学专业的，我是学临床，就是medicine background 的。但是我在听的时候，其实有特别多的共鸣。我觉得虽然可能是英国的这些案例，但其实因为我在做工作过程中，其实也更多的是从研究的伦理委员会的角度。从科研管理者的角度，或者从一个研究者的这个角度，包括作为患者家属，其实我在听这些案例的时候，我觉得每一个都有很多就是高度共鸣的地方吧。我想我就学习的体会很多，肯定大家都有哈。我就想从这四个不同的角色来跟大家分享我刚才听了的体会。一个呢，我觉得作为医院伦理委员会的委员，特别是做细胞治疗这些方面的伦理科研项目审查的时候，其实特别大的挑战，就是这个项目到底批还不批，特别是在首次上人体的时候，其实跟刚才那个讲者讲的很多例子，我觉得我们都有这样的困境，就是可能细节我就不说了哈。其实我就想表达的意思就是，刚才提的那句话就是 not gatekeeping but oversight， 我觉得这个其实真的是一个很大的一个，对我是一个我觉得就有点豁然开朗的感觉。就确实我们很多时候因为太想守住这个底线了，怕这件事情就是做的就是过于快了，忽略了风险，但可能有些时候确实可能有些会阻碍到创新。这是在伦理委员会的这个角色的一个体会。另外，我觉得就是确实现在我们前面其实我们翟老师讲的特别多，我是一直也是特别有好多认同，就是其实现在伦理审查真的是远远不够的，特别是面临这种就是咱们的这个医学的技术的创新这一块，其实真的是要的是一个治理体系。所以在这个治理体系这块，作为我们不同层级的管理者，无论说政府，还是说我们作为一线这种医疗机构，这些或者一些方的，或者一些发起，就是一些企业也好，无论各方，我觉得确实要有这种意识，就是做好伦理审查，就是不仅仅盯着伦理审查，我拿到批件了，我就可以做了。其实真的是要考虑的是这个伦理治理整体的这个生态系统。然后，刚才我特别认同，还有一点就是那个 evidence-based medicine， 就是本身我们来说，作为医生，肯定循证医学这个是毫无疑问的，也是在接触伦理这些以后，我觉得政府的很多决策真的也应该是循证决策，就不仅仅说这个技术能不能，确实是伦理方面要去判断，这样该不该，这样对不对，这样值不值。就其实刚才前面讲者里面，我觉得金句很多哈，就特别反复提到，就是我们在伦理审查，还有我们在做科研项目立项的时候，经常碰到的一个问题，就大家认为这个很新就等于好，其实这个就是一个带来就很多问题，而且好它还不代表它就有价值，它值不值得我们去做。刚才前面讲者也提到这个就是资源分配的这个问题，其实我想这个也是就是刚才我在听的时候一个体会，就其实确实我们作为不同层级的管理者的时候做决策，因为现在特别我们 医疗技术的创新确实太快了，而且范围也特别广。我现在的朋友圈在不断扩大，以前主要是医生、护士、统计师，现在法学的，然后还有伦理学的，甚至哲学背景的，还有数学系的，搞信息工程的。我自己其实就有点眼花缭乱的感觉，我觉得在这种很新、很快、这种情况下，就是觉得确实得要守住这种，就是证据在哪。就我们做这件事情，就像刚才我觉得讲者说的后面那句话，我也特别认同，就是我们现在都要去学习，无论学习型的组织或者学习型的研究者，但是我们就是还是得你做这件事得有价值吧，得提供好的证据，不是说我试一试就完了。我觉得这个是我自己刚特别大的一个感受。还有作为 researcher 的角度的话，我觉得其实现在因为法规特别多，就是以前是没有法规，现在法规特别多以后，大家我们作为研究者，其实申请的时候，很多都是觉得，就是为了拿到批件以后，很多时候其实有点 paperwork 更多。我觉得这种形式上的其实没有达到翟老师早上讲到的，就真正的这个实质性的伦理。其实现在大家太追求程序伦理，无论说我们伦理委员，还有我们就是各方面，反正就大家都这么交上去，但实实在在的，其实在就是你就虽然这个批件拿到了，但是你真的做到了吗？刚才里面还提到那个讲者提到那个 consent 这个事情，说其实你得到了他的这个 permission， 但是 rather than risk transfer， 我其实也是特别认同的，因为这个风险是在变的，就你或者你传递的这个信息准不准，方式对不对，其实这个都没有人去判断。researcher 你自己在面对患者的时候怎么交流的，其实这就是凭良心吧。我觉得就这个意思。其实我觉得作为研究者来说，就是不能仅仅说表面上合规，就我们要了解法律的要求在哪，伦理的要求在哪，但真的也要去知道实质上的这种伦理的这些背后的考虑，真的要去就是己所不欲，勿施于人，真正去保护我们的研究对象。然后还有一个特别重要的，就是大家反复提到的这个以患者为中心的研究，公众参与这块。其实这个我真实的也是这种感受。其实我从07年就开始做临床研究，但是我父亲真正生病的时候，我没有让他参与临床实验。就是我自己也在想哈，就是我中间也纠结过，说要不要参加。就我自己在想，我为什么没有参加？其实我都没有信任。就是我觉得这个其实不要再说，就是圈外人，就是我们自己在一线作为临床工作者也好，作为实验这些参与者、监管者也好，其实我觉得这块其实是很大的挑战。而且现在人工智能的这种给大家带来这么大冲击的时候，我觉得确实我们每一个人他有权利，就他要知道，就参与到这个决策过程中来，不仅仅说是因为想让他入组到研究中来，给你提供数据，因为他可能也是一个将来如果这个技术不当的话，他就是一个受害者，或者他是一个受益者。反正我觉得这方面就是怎么强调也不为过，真的就是应该让公众参与这个事情。可能刚才朱老师其实也是讲到，我觉得在我们可能现在还有更长的路要走，就这块可能就是还停留在理念方面，具体的举措方面其实还是远远不足的。再就是我想就最后吧，我觉得就是刚才因为讲我在听的时候我就在想，确实很佩服哈，就是从你看法学的角度，他分析的这个逻辑性特别强。我想可能而且是讲的更多的是从这些 case， 其实更多的是在临床应用，所以他直接会讲到这些人会去到 court， 就是跟我们就是完全不一样。就是我们可能更多的会是作为研究，他开始展的时候，一个通过伦理审查委员会。通过研究的伦理审查委员会来批准。那我确实觉得，就是我们作为伦理委员会怎么做好监管的时候，我觉得里面就做好正确的决策里面，我觉得也是受到了好多就是这些启示吧。我觉得也我觉得最主要的就是刚才提到的这些要这种学习型组织，而且要知道创新它是一个过程。就是不是说现在就暂停了，它可能现在停，经过讨论又可能重新启动。就它其实这是这样的一个，就是我们也不能太追求速度，就是要创新也要稳一些。还有一个我觉得特别重要的就是，我觉得确实要达成共识。就是我们可能因为现在参与方太多了，各种力量交织在一起。像我们特别是在深圳，因为更多的就是大家本来就是创新之都。或者就是这种情况下，各方面的力量都是希望很快。其实我觉得这些新的理念，就是我自己的学习体会还是很多的。谢谢。
非常感谢季平教授。So with this, we're immensely grateful to Professor Sir Jonathan Montgomery for having nourished our minds. And of course, it's not just Professor Montgomery, but also, of course, our wonderful commentators, Professor Zhu and Dr. Ping. Thank you so much for your very rich and enlightening comments, as well as comments from the audience. Since we have already nourished our minds, it's time for a bit of digestion. It is now time, of course, to focus on our stomach.